should also include recognition of Aboriginal rights, and this is largely the entrenchment of the UN DRIP, making them justiciable so that they're able to develop over time through the courts. That'll be the subject of our next paper, paper 3. The statewide treaty should also entrench Aboriginal control of Aboriginal affairs, which is the movement of all government departments and statutory authorities currently responsible for Aboriginal affairs to under the governance of the TRB. We'll look at that in paper 4. And finally, the statewide treaty should also include a framework for local treaties. This framework would need to be collectively negotiated with traditional owner groups. We see the Traditional Owner Settlement Act acting as essentially a floor to those negotiations. That would be the start of those negotiations, and negotiating up from there, we'd be looking to establish sovereign rights on country, and that will be the subject of paper 5. So moving into the content of this paper, I'll just give you a brief overview, and there's 5 discrete sections in the paper. The first part will look at what is sovereignty, just a short examination of that concept and its history. How has Indigenous sovereignty been dealt with in Australia? Part 3 will look at how has sovereignty been dealt with in other settler nations. Part 4 will look at whether the concept of Indigenous sovereignty is the same as the Western's concept. And then finally, we'll look at some practical measures that we think are possible for how sovereignty might be exercised in Victoria through this treaty process. So starting at the beginning, what is sovereignty? So the term sovereignty doesn't have a precise or defined or agreed meaning, but in general sense, it's about power and authority to govern. One common definition it's given is that it refers to supreme authority. That is, so there is no higher law. That's really referring to nation states. So states like Australia, where within its territorial jurisdiction, there is no other government or foreign state or power that the Australian government has to answer to. I think also it's important to acknowledge in discussions, especially around Aboriginal sovereignty, that there's also an implicit claim to legitimacy in sovereignty. Sovereignty seeks to legitimise power and to base it in some sort of moral or natural order. So this is seen in Australia in the sovereignty of the Australian Parliament and as a democratic institution. And it's particularly relevant, I think, in these discussions because what we're really talking about is the claim that sovereignty has not been transferred in Australia in a legitimate way. That there is an underlying flaw in Australia's claim to sovereignty. So a brief history of sovereignty. I mean, the concept as we know it in Australia comes out of Europe, in particular Britain. Within Britain, historically, sovereignty was held by the monarch, usually the king, sometimes the queen, who traditionally exercised more or less unfettered power. And in fact, that person was and still is referred to as the sovereign. Sort of through the Middle Ages in England, you saw the rise of the nobility, the rise of lords who, as they grew in wealth and power, began to challenge the unfettered power of the sovereign. They began to form parliaments. At first, those parliaments were to advise the sovereign, and later they were to direct the sovereign and essentially to take over sovereignty. So we saw by the middle of the 1600s, the English Parliament has completely usurped the monarchy. Don't know if you can see that picture there, but that's a picture of King Charles I getting his head chopped off, which was when Parliament usurped his sovereignty. And this has led to a position in Britain today known as parliamentary sovereignty. So this means essentially that Parliament has supremacy over all other institutions, and it can make and unmake any law and is not bound by any written law. In Australia, this is the broad tradition that we've inherited, but we don't have what's known as, well, we don't have pure parliamentary sovereignty because our Parliament is bound by a written constitution, the Australian Constitution. That document divides sovereignty between the Commonwealth and state governments and dictates who will do what. And how it does that is principally through Section 51 of the Constitution. Section 51 is essentially a list of all the things that the Commonwealth Parliament can make laws about. Anything that's not on that list is left to be dealt with by the state parliaments. The type of things you see in Section 51 are fairly the sort of things you would expect to run a sort of modern nation state. They are dealing with the military defence, interstate trade and commerce, currency, naturalisation, immigration, and so on. But there is nothing within the Constitution that says the Commonwealth is the only body that can deal with matters related to internal Aboriginal sovereignty or issues. So theoretically, there is nothing that should prohibit a state from entering into a treaty with an Aboriginal nation within its own state boundaries. Moving on now to have a discussion about how sovereignty has been dealt with in Australia. Oh, sorry, and I should point out too, if people want to put questions to me, feel free. You can add them in the Q&A box. Perhaps some of my other panelists could alert me if a question comes up, and I can try and answer it on the spot. Otherwise, I can answer them at the end, and we'll try and have a space for open discussion. So part two, how has Indigenous sovereignty been dealt with in Australia? Well, it's been raised in the courts on several occasions, but unfortunately the courts are not really in a position to give us an answer. This is because there's a long established principle that a domestic court can't question the sovereignty that created that court. It sort of leads to a logical impasse where the court can't question the authority above it. But the cases in which it's come up, Co and the Commonwealth as early as 1979. It raised its head again in Mabo. The Co family had another go in 1993. And most recently, I think we probably all thought that was the end of Australian courts considering sovereignty, but it's raised its head again most recently in Love and the Commonwealth, which came out just last year. So just a brief overview of some of the facts of these cases. So Paul Co, in this first Co case, he is a Wiradjuri man from New South Wales. He sued the Commonwealth and the UK on the basis that the sovereignty and possession by the British was wrongly proclaimed at the time of colonisation. What he argued was that the Crown had obtained the land under the falsehood of terra nullius, where in fact the land was taken by conquest, and there had been no treaty or lawful compensation or international intervention, as would be required by international law if you take land by conquest. Ultimately, the High Court decided it couldn't hear the claim. Justice Jacobs said these are not matters which are municipal or domestic these are not matters of domestic or internal law, but of the law of nations, and are not able to be considered in a court exercising jurisdiction under that sovereignty which is sought to be challenged. So it's this concept that sovereignty is the law of nations, it's the law between nations, and it's not something that can be challenged internally. In Mabo, the issue came up again, but in this case, the applicants weren't arguing that settler sovereignty was improperly acquired or invalid. Instead, they were making a narrower claim that some Indigenous rights, so that they acknowledged that sovereignty had been transferred, but that some Indigenous rights had survived that transfer. Justice Brennan, citing the Sea and Submerged Land case, he again asserts that the acquisition of territory by a sovereign state for the first time is an act which cannot be challenged or interfered with by the courts of that state. So he holds to that line that we saw in Co. But he also says, although we can't look at the question of whether the acquisition was valid or what have you, we can look at the consequences of the acquisition. And we are able to make a decision about essentially what happened to the original inhabitants' rights when that acquisition occurred. So in that sense, the court assumes the sovereignty is valid and then starts an investigation into what does this mean for the people that were already in the land, already having pre-existing rights. Now, what happens to original inhabitants' rights upon the acquisition by another sovereign under international law? That question is really determined by the manner in which the land was acquired. The usually accepted methods of acquiring land is either through conquest, secession, which essentially means the freely giving up of the land, or terra nullius, that is occupying land that is not inhabited by anyone else. So the court, it dispensed with terra nullius because that was an obvious lie, but it didn't go as far as to say that sovereignty was acquired by conquest. Instead, it sort of reached this middle ground where it said the land was settled, but yes, it was inhabited at the time it was settled. The court went on to find that because it was inhabited, it must be assumed that the new sovereign, that is the British sovereign, had intended to respect the pre-existing rights and interests in the land. And so, in fact, yes, some Aboriginal rights had survived the acquisition of sovereignty and could be recognised in Australian law. And those rights are native title rights. Now in '93, so just after the Mabo decision, with the rejection of terra nullius, Isabel Coe, that's Paul Coe's sister, sorry, Paul Coe from the original Coe proceeding, had another go. She brought proceedings on behalf of the Wiradjuri tribe as a sovereign nation of people, or in the alternative as a domestic dependent nation entitled to self-government and full rights over traditional lands. This idea of a domestic dependent nation, that comes from US law, and we'll look a little bit at that as we go on. But in any event, she was unsuccessful. Chief Justice Mason entirely rejected the notion that Mabo gave any sense that there was sovereignty adverse to the Crown, and basically said there's no such thing as a domestic dependent nation in Australian law. And I think at that point, it seemed quite clear that the pursuing ideas of sovereignty in Australian courts was a dead issue. Until last year, when it raised its head again in a kind of unexpected way in Love and the Commonwealth of Australia. Probably people are familiar with the facts in this because it was quite widely publicised last year. But essentially, it involved two plaintiffs. They were both born overseas, but had Aboriginal heritage, had lived most of their lives in Australia, and had deep connections within their Aboriginal communities. However, as non-citizens, they were technically here on permanent resident visas. If you commit a serious criminal offence on a visa, it's mandatorily that visa will be revoked and you will be deported from the country. Now, how the Commonwealth regulates this is through the Migration Act. The Migration Act relies on the aliens power in section 51 of the Constitution, the same section I was referring to earlier. It's those list of things that the Commonwealth is able to make laws about. It's able to make laws about aliens and essentially deporting them from the country. So the plaintiffs said they couldn't possibly fall within the understanding of the word alien, because even though they weren't citizens, they were Aboriginal Australians. Now, the High Court decided 4-3, so 4 justices found for the plaintiffs and 3 found against them. So they won by a narrow margin, but the majority found that that using the tripartite test in Mabo, that Aboriginal people are not within the reach of the aliens power in the Constitution. The tripartite test is probably quite familiar to many people that have been involved in Aboriginal affairs. It's essentially that a person self-identifies as Aboriginal, has descent from Aboriginal ancestors, and within their own community are recognised as a member of that community. So all the 4 judges who found for the plaintiffs gave different reasons. They all came to the same conclusion, but gave different reasons for it, which makes it somewhat hard to draw solid understandings from those judgments. But in essence, the majority all considered that Aboriginal Australians had a unique position in Australia, both in relation to its land and waters and also to the Australian polity. Now, the interesting thing in terms of sovereignty, I think that comes from this case, is really the position of the 3 judges who found against the plaintiffs, because they all said that by recognising that Aboriginal Australians have this kind of additional right, you are in a sense giving rise to a competing sovereignty. 2 of the justices expressed concern that if you're going to rely on this tripartite test, you're giving authority to the Aboriginal community and Aboriginal elders to say who is and who isn't within the scope of the Commonwealth Parliament. Yeah, and that is itself an exercise of political sovereignty. I think there is something to what the minority judges say there. There is in this decision a strange sort of logical leap that people could have this special ability not to be aliens in this country, even when they're not citizens. It certainly, to my mind, starts to imply that they must have some other connection, which I think the minority judges identify as sovereignty. I should point out they're not saying that's a good thing, but nevertheless, I think their logic is kind of right. So I think that Love and the Commonwealth shows us that there's a very thin line between a recognition of some Aboriginal rights as surviving the transfer of sovereignty and the survival of sovereignty itself. Now, the court made clear in Love that it might be open to exploring this ambiguity, but it's still never going to completely step over the line. The judges that found for the plaintiffs, disavowed any suggestion that they were talking about sovereignty, and the court will essentially never go there. And on that basis, I think Love ultimately confirms that sovereignty can't be dealt with in domestic courts, and Aboriginal people can't have their sovereignty declared or validated in the courts of another sovereign power. And all of this is to say, really, that I think we can't conceive of sovereignty as a legal issue, because it's really a political issue. It is this law of nations that's above the internal law of different political entities. So moving on to part 3, and I'm conscious of time, so I'll try and move through this relatively quickly. But questions of sovereignty and First Nations, they affect all settler nations. They're particularly relevant, I think, to this discussion is the United States and Canada, Aotearoa and Scandinavia. Also interesting is that, with the exception of the United States, none of these settler nations have expressly recognised the sovereignty of Indigenous peoples. Instead, they have, so instead of an express recognition of sovereignty, what they do is establish agreements and institutions that allow for some level of self-determination and self-government, in a sense, a type of practical sovereignty. Now, I don't think we have time to examine each of these, the arrangements in each of these nations individually. So I'll just focus on Canada and the United States. So, as I said, Canada doesn't recognise the sovereignty of its First Peoples, but it does allow for a process of limited self-government. The history making of treaty in British Columbia is slightly different to the rest of Canada, in that it was colonised. It was the last sort of area in Canada to be colonised, and there are relatively fewer historic treaties there. Even where there are historic treaties, they tend to be very simple documents which are really about exchanging goods for land. There's no recognition of governance arrangements of Indigenous peoples or attempt to have an ongoing relationship. This lack of treaties and the fact that the treaties themselves were kind of shells left a lot of ambiguity around land ownership in Canada in a way that's probably quite familiar to Australians. And in 1973, they had the case Calder and the Attorney General, which recognised something called Aboriginal title, which is this continuing property right in land that First Nations Canadians had, which is similar in many ways to what we would call native title. Following that 1973 decision, there was a series of critical land rights cases. It propelled an Aboriginal land rights movement and pressured particularly the British Columbian government to engage with First Nations. This history, I think, is all very familiar to Australians. In fact, it's quite eerie. We almost follow a similar timeline. So in British Columbia in the 90s, the BC government sets up the British Columbia Treaty process. Under that process, treaties are entered into with the provincial or state government and the Canadian federal government. The treaties themselves, I think it's interesting to note, they contain many of the things that are available in Victoria under the Traditional Owners Settlement Act. We will look at this in a later paper in greater detail. And in fact, I think the Traditional Owners Settlement Act was in part based on some of this Canadian stuff. But the things that are available under treaties is a cash settlement, a transfer of Crown land, rights to hunt, fish, gather, etc., some rights over development and natural resources, and cultural promotion. Now, if you take those things as a whole, that's basically what you get under a Settlement Act agreement. But the Canadian process goes a step further and conveys upon the First Nation a limited right of self-governance. There is no template for what this self-governance might look like, and the content is to be negotiated between the individual First Nations. But they do sort of set out essentially like a menu essentially of the sorts of things it might include: education, language, culture, police services, housing, property rights, and so on. First Nations remain subject to Canadian and British Columbian law, but they are able to legislate on areas pertaining to provision of public services, such as healthcare, education, and so on. They are able to make laws about zoning and transportation, although they are required to consult with the local community when making those laws. So just as a bit of a case study, look at the Tuasin, just outside of Vancouver in British Columbia. They first entered their treaty in 2007. They established a legislative assembly that includes a chief and 12 elected legislators. At the time of writing the paper, that legislative assembly had passed 29 laws. And I think it's interesting just to have a look at the breadth of the sorts of legislation that this group is making. They passed legislation on culture and heritage. That's roughly similar to the Aboriginal Heritage Act in Victoria. They have a Children and Families Act that's about child protection. These are the sorts of subject matter you would, I suppose, expect them to be making law on. But they've also got a Freedom of Information Act. They have a Property Tax Act, and they have an Administrative Review and Judicial Proceedings Act. I mean, this is the type of legislation that every government has. These are the sort of nuts and bolts things that a modern nation state or like the state of Victoria has. If they want to pass any of these laws that relate to health, educational, social services, that has to be agreed upon by the BC and Canadian governments before it actually becomes law. I think the justification there is that they want them to tie into the wider systems, although of course there has been criticism that is impeding on Tuasin sovereignty. In any event, relying on their own legislation and their control over planning and development, the Tuasin have rezoned some of their lands for development. They've developed their own shopping mall and a housing project in which they sell housing to non-members, to non-tribal members. So they've been able to use these rights as a basis for economic development. It should be remembered that this treaty doesn't expressly recognise the sovereignty of the Tuasin, but I think it's quite clear from how they're acting. They're definitely acting like a sovereign people. To contrast that with the United States, they have a different history of treaty making, and I'll look here at the Navajo. So this is more of a historic treaty. It was first entered into in 1868, and this treaty established the Navajo as a sovereign nation outside the basic structure of the Constitution. So they are a different political entity than the United States. The basic terms were that the Navajo agreed that they would stop raiding, they would remain on their reservations and send their children to school, and in return, the United States would allow them to live on the reservation, they would retain their sovereignty, and they also promised farming equipment and supplies. In the present day, the most significant element of this treaty is its recognition of sovereignty, and it's establishing the Navajo Nation as a domestic dependent nation, protected by federal legislation. The Navajo government has wide powers, wider than the Tuasin in Canada. They are able to tax, they are able to establish their own gaming legislation, which allows them to run casinos as an economic development project. They also have rights over criminal law. One of the sort of unusual things in this area is that in the United States, while felonies are delegated to the federal level, so the more sort of serious crimes, the Navajo run their own criminal justice system. They have their own police force, they have their own jails, they run the whole show. They also have, in the last 50 years, developed their own civil courts, and the judgments in those civil courts are upheld in the Arizonan state courts. So they have these very distinct markers of sovereignty, which is essentially the use of force and ability to detain people and to enforce judgments. There is also this concept of the domestic dependent nation. So this is an idea that developed in US common law, that Native American nations were distinct independent political communities, but still remained subject to federal law. So they possess internal governmental power over all their affairs, but no external governmental power. So they can't have relationships with foreign nations. That's the US common law position, though of course it's disputed by many of the tribal nations themselves, who believe themselves to have equal status with the United States government. I realise this is a very quick discussion of a very complex subject matter, and I apologise. If we had more time, probably each of these parts we could spend an hour on itself. But in any event, moving on, trying now to have a think about the Indigenous concept of sovereignty, whether it's the same as the Western concept. So in the European tradition, sovereignty is very much about authority and about power, who holds it and how it can be legitimised. But Indigenous peoples, both in Australia and internationally, they've expressed more nuanced conceptions of sovereignty. They are political concepts, but they also are sort of spiritual and cultural concepts. The paper includes this quote from a First Nations academic in Canada, which I think is useful. He talks about the challenges to disconnect the notion of sovereignty from its Western legal roots and to transform it. It is all too often taken for granted that what Indigenous peoples are seeking is at its core the same as what countries like Canada and the United States possess. So we shouldn't necessarily take for granted that when Aboriginal people assert sovereignty, they are saying they want to be like a nation state. They may be saying that, but they may be saying other things as well. In Australia, there was a recent attempt, I think, made to define sovereignty in the Uluru Statement from the Heart. And I think that gives some sense of a broader conception of what sovereignty might mean. In that, it's a rather lengthy extract there from the statement, but it first establishes that Aboriginal and Torres Strait Islanders were the first sovereign nations on the Australian continent. But it then talks about sovereignty as a spiritual notion, about the ancestral tie between the land and the people. And this is the link, they say, for ownership of the soil, or better, of sovereignty. It has never been ceded or extinguished and coexists with the sovereignty of the crown. So that in its, that's a wider notion of Western sovereignty. Western sovereignty is about authority. When that authority is extinguished, the sovereignty is gone. This is talking about a continuing sovereignty that can't be extinguished. Now, I recognise that the Uluru Statement from the Heart, there's no consensus on that statement, and I don't think there's any consensus on among Aboriginal people about the term either. This is true, just as true in the European tradition. Sovereignty is an ambiguous term, and there's debate in all communities about its exact meaning. And while I don't think it's possible necessarily to reconcile all these concepts of what sovereignty might mean, but we can start to examine what practical sovereignty might look like. And from this, I draw from a Native American academic, Robert Allen Warrior, from the University of Arizona, and he talks about the idea that exercising sovereignty does not necessarily mean having full control over all the details of government. He's saying that Aboriginal people don't necessarily want to issue their own postage stamps, they don't want to issue their own currency, have their own police. He's saying that's not the point. The point is for traditional owners to determine what they want to hold dominion over and what will improve the lives of Aboriginal people. The quote from him included in the paper says, "The struggle for sovereignty is not a struggle to be free from influence from anything outside ourselves, but a process of asserting the power we possess as communities and individuals to make decisions that affect our lives." So with that in mind, moving on to look at some of the practical ways that sovereignty might be exercised in Victoria. I'll just skip through this on the basis of time. But remembering that this is our idea that you have this TRB that will exercise power as a sovereign body. Now, thinking about how the TRB might hold sovereignty is an interesting idea. We say that if you're looking for where sovereignty resides in Victoria, you need to look at First Nations groups, whether you call them nations or clans or native title holders, whatever the term. They are the bodies that had sovereignty that pre-existed white settlement, and we say have a legitimate claim to continuing sovereignty over their respective territories. Now, it's not uncommon for smaller sovereign entities to voluntarily form larger sovereign entities and bind together to meet their common problems and take advantage of that larger scale. A simple example is Australia and the Australian states, which federated to form the Commonwealth. Another example is the United States, where 50 or so states federate to form the United States. We can even find sort of more culturally appropriate examples closer to home if you sort of think of the Kulin Nations being some sort of confederation of individual traditional owner groups that retain their own sovereignty, their own individual sovereignty, but in certain circumstances essentially band together to form another political entity. Now, the advantages of this, I think, are pretty clear. Aboriginal nations the resource and scope available to a united group of traditional owners will exceed what any traditional owner group could achieve on its own. Now, in BC, where we see individual traditional owner groups exercising essentially self-government or sovereignty, that is largely possible because there is so much unsettled land. There is a vast landscape over which that sovereignty can be recognised, well, can be exercised, where it's not going to impact settlers, which makes it more obviously politically palatable to the BC government. Likewise, in the United States, where we see Native American nations exercising their sovereignty, it's largely in the remote southwest part of the country, in areas that are covered by historical native reserves, and doesn't impact on settler rights. Given the extent of colonisation in Victoria, there is not really the same opportunities for unfettered individual traditional owner group sovereignty that isn't going to seriously impact settler rights, and therefore becomes politically difficult to achieve. As such, we think there are ways that you can exercise sovereignty that can be better achieved through the TRB, and the exercise of sovereignty can be looked at the state level through the creation of a sovereign TRB, and then also at the local level through individual traditional owner groups, nations, or clans. So, conscious of time, what sovereign powers could the TRB, could this statewide body exercise? So we've suggested, it could operate as a traditional owner parliament, it could act as a voice to the Victorian Parliament, or it could select members to take up reserved seats in the Victorian Parliament. These could be individual options, or they could also be implemented in some sort of combination. Acting as a traditional owner parliament, we don't see the TRB as having jurisdiction over land. That would be left to individual traditional owner groups, and instead it would have dedicated policy areas. Exactly what those policy areas would be is, of course, open to negotiation and needs to be led by the Assembly. But using that Robert Allen Warrior approach of looking at the things Aboriginal people want to hold dominion over to improve the lives of their people, we think you need to, where does the state of Victoria and Aboriginal people most frequently come into conflict? Where are the areas that Aboriginal people's lives have been impacted negatively by the state? And I think, what we think comes up, of course, is cultural heritage, traditional rights around hunting and fishing practices, but also things like healthcare, education, social services, particularly with Aboriginal child removals, criminal justice, and a potential extension of the Koori Court, policing and treatment of Aboriginal people detained or arrested by police. These are only put up as examples, as the kind of things that that the TRB may want to hold legislative power over. In terms of the combined approach, so you would have the Aboriginal Parliament with those legislative powers. We think they should probably be introduced incrementally. I wouldn't suggest on the first day that necessarily the TRB is legislating on each of these things, but they could draw them down incrementally as according to their needs. There's also the question of whether there would be some shared sovereignty. As we saw in BC, when legislation is made, it also requires the agreement of the Victorian government, and that will be an issue that will need to be addressed. Where there wasn't legislative power, the TRB could act as a voice to Parliament on essentially everything else, on everything that's not covered by a legislative power. The TRB could act as a voice, providing non-binding advice. And seats to Parliament in Victorian Parliament would essentially oversee and cement the shared sovereignty. In New Zealand, they have directly elected Maori members. We're suggesting as a point of difference that it would be the TRB that would select members to sit in the Victorian Parliament. And in that way, they would sit on both bodies. So it would sit both in the Parliament and on the TRB simultaneously. Now, just to finish off, what sovereign power could be exercised by individual traditional owner groups? This, I think, is a harder question because that land is not necessarily so available and we will look at it in depth in a future paper, in paper 5. But for completeness, I'll just touch on a few ideas. What we would suggest is a flexible approach. In BC, when they hand down jurisdiction to groups like the Tuasin, it's not handed down all at once. There is essentially a smorgasbord or a menu of the sorts of things over which jurisdiction can be provided, and the groups draw them down as they want to, or have the capacity to do so. We would suggest a similar approach here. But there is also, I think, a question of sovereignty over missions, national parks and Crown lands, and integration with local government responsibilities and services. So as I've said, the highly settled nature of Victoria means that many of the structures you see in BC and the United States are less practical because there's less land. But there are some traditional owner groups that continue to occupy former missions, and there's no reason why they couldn't receive sovereign power over those areas. Unfettered control of planning and land and environment laws could be handed over. That could be used for economic development or for whatever purpose the group chose to use it. National parks, I think, are another landmass in which sovereignty could potentially be exercised. At the moment, these national parks are available for joint management under the Settlement Act, but I don't see why they couldn't be subject to sovereign control and essentially handed over to TOs for use, with the ability to charge appropriate fees and so on. The other area of unused land, essentially, is all of the vacant Crown land throughout the state. Currently, all of this land is managed by what are called committees of management. There's over 1,200 of them. They're local councils, water authorities, etc. And there's no reason why traditional owners couldn't move into this space and manage that land under their own sovereignty, if they wanted to do so. In terms of integration into local government, this could work in much the same way as the TRB works at the state level. So that is, you could have traditional owner groups forming a separate legislative body alongside the local government. You could have them acting as a voice to the local government, or having reserved seats on the council. And noting the time, I think I'll stop there and see if anyone would like to raise any questions. Anya Isabel Coe, yeah, exactly. So if you want to put questions into the chat, I can answer them. Doesn't look like we're getting any questions through. I might throw back to Paul, if you're there, Paul.
I am still here. Okay. I think if there's no further questions, I think you've done quite a comprehensive job there, Dan, of covering all the different types of examples and possibilities that could form part of future treaty negotiations, and recognising how we understand sovereignty as part of that, and that there's I think the paper goes into a lot more depth if you've downloaded it and been able to read it, and it's a good summary of that paper. So I hope that everyone has. I think if there are no questions, I hope that was clear for everyone, and that was that you've got a lot out of it. And we hope to see you at the next session. And just a reminder, when is that, Dan?
The next one, bear with me, is I think on the 3rd of March.
Okay, just a few weeks' time.
Yeah, on the 3rd of March, we'll be discussing UN DRIP and how that might be enshrined in Victorian law.
Excellent. And just to note that Declan has shared the link to the discussion papers in the chat at the moment, or you can simply go to our website and find that under treaty. You'll find the discussion papers there to download at your own leisure. So thanks, Dan. Really good job. And yeah, thanks again. And we look forward to the next session on the 3rd of March.
Thanks, Paul.
Bye, everyone.